To learn more about the Google antitrust case, Prof G Media's Mia Silverio spoke with Yosef Weitzman, a reporter who's in Washington covering the case. Here's that full interview. Enjoy.
My first question regards your first post covering the Google trial. You describe it as a morality play, quoting a Microsoft antitrust lawyer. Can you just say more about what you meant by including that quote, and then more broadly speak to the kind of push and pull between facts and narrative and likability in this case?
Yeah, definitely. So that quote about an antitrust trial, and really any trial being a morality play, was from David Boies, who's kind of a very well-known trial lawyer, and he was the lawyer who was tapped by the government to lead its case against Microsoft back in the late 1990s. And I think what he's getting at, with an antitrust case, especially one as big as this, right? There's going to be tons of evidence, tons of documents, tons of testimony that comes out over the course of this trial, which is expected to last more than 2 months. But the person deciding this case, Judge Mehta, is just a singular. He's a judge. He's a smart guy. He's familiar with antitrust law, but he's just a singular person, and he's not really even an antitrust expert himself. He hears all kinds of cases. So it's just not possible for him to, really take in every single piece of information he's going to get throughout this trial. He's going to have to, he's going to be seeing competing versions of facts, and he's going to have to choose, which narrative he believes the most. He believes in the most, and in a lot of ways, this is what David Boies thinks. I think this is what a lot of other people think. That's going to kind of come down to which side is able to put on the better story. And that involves developing themes. So, for example, DOJ started its opening statement by saying this is a trial about the future of the internet. And meanwhile, Google's arguing that the government is trying to punish Google just because it's really good. So it's about themes, but it's also about credibility, right? Like which lawyers, which witnesses the judge believes. So that's part of why this trial is a morality play as much as it is, a search for truth.
Mm-hmm. I want to go back to something you mentioned. You said that this judge is not specifically an antitrust judge. This is a really significant case. Why wouldn't they pick a judge that specializes in antitrust cases?
Yeah, so actually this is just how the federal legal system works, that we have, it's what are known as generalist judges. So there are a couple specialized courts, like there's the Court of Federal Claims, which deals with a lot of patent claims. But for the most part, judges hear all kinds of cases, and they're just randomly assigned the cases they hear. So Judge Mehta was randomly assigned this case. And I think, the theory behind having generalist judges is that you want to avoid having judges who are kind of captured by a specific industry, or, aren't able to take, a broader outlook and understand what, the implications of a decision might be, beyond a specific area. But then the trade-off you get, right, is that you have judges having to make decisions about incredibly complex, difficult factual and legal matters when they aren't actually experts in that specific area themselves.
Mm-hmm. That's interesting. So you've been in the courtroom for the past 2 days of the trial, right? What has the kind of tone been like, and has anything about the proceedings surprised you so far?
Yeah, definitely. So I think, I think yesterday, which was the second day of the trial, felt pretty different from the first day of the trial. The first day, there were people lining out the doors of the courthouse, hours before the trial actually started at 9:30. A lot of big names showed up to watch the trial. Like Jonathan Cantor was there, who leads the DOJ's antitrust division. For Google, Kent Walker was there, who's their chief legal officer, and he was actually just profiled in the New York Times. So there was definitely an air of, excitement and drama. Like it felt like, okay, this is a big historical event. And it still feels like that to a degree. But like yesterday, for example, I think there still is like an overflow room, but anyone could have just walked in to the courtroom yesterday and grabbed a seat. Like it wasn't it was pretty full, but it wasn't packed. And now we've actually gotten into the testimony. So it's not so much, both lawyers are still trying to develop the themes that they're working on. But we're not hearing the opening statements. We're not hearing kind of, these broader claims about what this case is about. Now it's more about working with a chisel to develop their cases. So it's still exciting, but it feels like we're, starting to settle in for, what will be a long trial over the course of the next 2 months or so.
Mm-hmm. How do you anticipate the prosecutors will try and prove that Google being the default harms consumers? Because I personally love using Google, and I do feel that it's relatively easy to switch browsers. So I just wonder how they're going to kind of maneuver around that.
Definitely. So I mean, that's a key issue, and I think it's also interesting in this case because Google is free. So a lot of times in antitrust cases, the prosecuting party will try to argue that a certain action harms consumers because it raises prices, and if there was better competition, prices would be lower. But that argument doesn't really work exactly here because Google's free to begin with. But I think there are a couple of different ways that the government is still going to try to argue that Google causes consumers harm. So I think the first, the main argument is just that because Google has so much monopoly power and is able, according to the government, exclude competitors through these default search engine deals they make. It's just not possible for other search engines to compete with Google. So we just don't know what the best possible search engine could look like because other companies haven't been able to compete. So like there was one company, Neva, a startup that tried to develop its own search engine, and it went out of business because it just couldn't compete with Google. So that will be a part of the case. And then another way that I think the government might try to prove that Google causes consumers harm, and related to that, sorry, one more point on that. Related to that, I think the argument would also be that since Google isn't facing effective competition, they themselves don't feel the pressure to innovate like they would, and make Google the best it could be, like they would if it was a competitive market. The other, theory that the government is likely to advance is that, so Google makes its money through advertisements. So there's a market for consumers and using search engines, but then there's also a market for advertisers in placing their advertisements on different search engines. And the DOJ will likely argue that because of Google's power in the search advertising market, they're able to raise prices for advertisers kind of above competitive levels. And I guess indirectly, that those increased prices kind of get passed on to consumers because if companies have to, pay more for their advertisements, in theory, they'd also have to charge more for their products to offset those additional costs.
Isn't that also the subject of a second lawsuit? Like, aren't there are a variety of them, but there are two big ones, right? And the advertising is like really the crux of the second suit. Is that correct?
Yes. So both DOJ and a coalition of state governments are involved in this case against Google. And the DOJ and state are kind of aligned on this first issue of whether default agreements are causing competitive harm, and they're actually arguing that it causes competitive harm in both the general search market and the search advertising market. But then there's also this separate claim being pursued just by the states, which is that Google's proprietary advertising management system, which is called SA360, which you can actually use to like buy ads on Bing as well. The argument is that Google has not developed that in a way so that it is as compatible with its competitors as it is with buying ads through Google. And so that's kind of an additional way in which the states are bringing this separate claim against Google that the DOJ is not itself bringing. But I think both claims kind of combine a lot of the same arguments about how, you know, Google has a lot of power in the market, and how they're using that market to allegedly exclude competition.
Mhm. Yeah, it just seems to me that if there were a really compelling other search engine that you could download, and a couple people had downloaded it and they thought it was great, and it kind of spread, like people would just switch and use the
Yeah.
new competitor. And so it's like maybe they're just like haven't been any better products made. Is that like a
I
legal
think
argument that could be presented?
100%. I think like in a lot of ways, like that's the core of Google's defense. Like people use us because we're the best. If we weren't the best, like they could easily switch. And I think that, they've said, if you want to switch your default search engine, like all it takes is a few clicks. So that's 100% an argument Google is making. The government's response to that is it's kind of, there's there's multiple aspects to it. One aspect is like if that's the case, like if people really use Google just because it's the best, like why are you paying billions of dollars to Apple to be the default search engine? Like why don't you just save that money and people will use Google anyway? Um, and then I think another argument that the DOJ is making, and they've already started putting testimony in about this, is that it's actually not so easy to switch. Like defaults have like a pretty powerful psychological effect, and even if it only takes a few clicks, people don't necessarily realize that they can change their defaults. And changing the default can be a little tricky. So like for example, yesterday DOJ called a professor from Caltech who's like an expert in consumer psychology, um, and he talked about the power of defaults and walked the court through um, how one would have to change. Like if so, like on an Android phone, there's a default search engine widget, and if someone wanted to change that to a different browser, he walked the court through how many steps that would take. He said it would take 10 steps, and he said that's already assuming in the first place that the user would know exactly which steps to take. So there's also disagreement about just how easy it is to actually switch your default.
That makes sense. I'm wondering if you think it's possible, though, that current antitrust law is perhaps a bit outdated, offers kind of outdated regulatory guidance for today's companies. In many cases, I think for internet companies, scale allows network effects, and those network effects actually make the product better. Do you think that's possible, that this, like our antitrust laws were created so long ago when we were dealing with very, very different companies that were producing largely physical goods, and that's just not the case today with big tech companies? Thoughts on that?
Yeah, I feel like I probably don't know enough to really comment. Give it a good comment about that. I think definitely like that is like an open question. I think beyond this case, like this case is being brought under Section 2 of the Sherman Act. The Sherman Act was passed in 1890, right? So it's more than 100 years old, and it has been used like over the last 100 plus years, in the 20th century um, to break up bid monopolies. Like that's what they used against AT&T. That's what was used against Microsoft. Um, so it's been and I think many people think those were ended up leading to good outcomes. but I think there's definitely a big question about, whether it's, that law from 1890 is equipped to regulate, bid tech companies today. And I think you could argue, you know, made various arguments about which way the law should go. Um, but just that, regulating bid tech companies with 100-plus-year-old laws is not like an optimal path to be taken.
Yeah. How important do you think it is that Google preemptively instructed employees to use messaging that would delete after 24 hours when talking about sensitive material? I read that and I was really surprised and immediately wondered why every company doesn't do this.
Yeah, well, I think it is important. It's definitely an important aspect of the government's case. I think, Judge Mehta is kind of the only person who actually knows how important it will be to his decision. So one of the big, sound bites that came out of the Microsoft case is that, there was this quote that like Microsoft was trying to cut off the air supply of its rivals, and that, the government kind of centered its case around that quote, um, and it was very damaging to Microsoft in that case. So I think, right, that the response um, of companies has been, all right, we have to be careful about what we say because those kinds of quotes can look really bad in trial. Um, and but it can also look bad to, hide evidence. And like you have to wonder what was in that evidence. So the government, I think the government is trying to argue, we like from what we already know, they're violating the antitrust laws. This is anti-competitive behavior. They knew they were acting anti-competitively. But you also have to wonder about what we don't know, and what it says about Google's credibility, that they were using history off chats to kind of hide documents. And I think, the reason that not every company does that because it doesn't look good when it comes out, right? Like when the government brings a lawsuit, if it survives a motion to dismiss, it begins this process called discovery, which is where like both sides turn over all the evidence they have. As part of that, the defendant is required to like turn over all of the relevant evidence they have, all the internal communications they have, unless they're privileged for some reason. And the government is arguing that even after Google was obligated to turn over this evidence, they were like intentionally using these self-deleting chats. So I think it's an important part of the case, both because it leaves open this question about what evidence would have been discovered if these chats were handed over to the government, but also because it's another attempt by the government to kind of attack Google's credibility.
Yeah, I also read that they would instruct certain employees to include a lawyer in certain emails so they could claim that there was attorney-client privilege or something like that. That was also so interesting and so sneaky. I'm wondering if you, in theory, were a lawyer for Google or something, and you are asked about should we take these preemptive measures or not? And you kind of maybe there were some things that didn't look so good in what was being said. Do you think you would have advised them to try and get rid of the evidence, or like do you think it looks worse to have this potentially incriminating evidence or to have deleted it?
I don't know. I don't know. I will say, like, lawyers are like, regardless of like how something looks, there are certain like ethical rules that lawyers are bound by. So, in theory, like something could look bad, but a lawyer should still, advise their client to do that just because they're ethically bound to. And I don't feel like I know, or even the public really knows. Some people would say we do. I don't personally want to like comment on what I would do if I were in that situation, or whether how unethical, or whether that kind of policy was unethical. Um, but I think, that's kind of like a basic ground rule of litigation, just that there are certain, ethical rules, certain disclosures, um, that you have to make in order for, there to be a fair trial and for, the ultimate ruling to be correct. So I don't think, yeah, it's not quite as simple as like, which is better for Google? Is it better if like these emails don't come out? But it's like, it seems like they're, trying to hide the emails because there's also the aspect of like, okay, is Google and Google's lawyers even allowed to be doing that in the first place?
Yeah, definitely. So I've just two more questions.
Yeah.
If Google loses, I know it's kind of more complicated than just a win or loss, but what do you think the most likely outcome would be, or like maybe a couple of the most likely outcomes? Like, if Google has to divest certain portions of its business, would it be able to have some input in that, or would the judge give strict instructions on here's what you're going to do now?
Yeah. So I think it's really hard to know, partly because this part of this trial that's happening right now is actually only dealing with whether or not Google is liable for violating the antitrust laws. If the judge finds that they are liable, then there would actually be a whole separate other trial to deal with. Okay, Google violated the antitrust laws. Now, what are we going to do about this? So Google would definitely, if Google is found liable, then Google would definitely have an opportunity to argue, what should be the result. Should be the result of that. But it's just really hard to know right now. Like people, like there could be breakup remedies where the judge orders Google to like break off certain components of its company. Um, that's that was what happened after the big AT&T case that AT&T was forced to break up. Um, or there could be, it could be there's no breakup, but Google isn't allowed to like pay for these default deals anymore, and browsers and device makers have to actually, when a user opens their browser or their device, they have to like get a choice of the different search engines. So they actually have to choose which search engine they want to use. That's another remedy that a lot of people have discussed. And obviously there are other possibilities too. But it's just like it's at this point it's really hard to know just because they haven't even started putting out evidence or arguments about that.
Mm-hmm. So there's a long road ahead, essentially.
Yeah, I don't depending on this trial will go till November most likely, and then it could take a couple more months until we actually get a ruling from the judge. And then yeah, there would have to be a whole other if Google did violate the antitrust laws, there'd be a whole other trial. And then who knows how long that final ruling would take. And then of course, Google could also appeal it. And this is the kind of case that would, it could very well find its way up to the Supreme Court. So yeah, this isn't something that's gonna resolve itself in the next few weeks.
Yeah, does not sound like it. So finally, what do you see as the main differences or similarities between this case and the Microsoft case in the late 90s?
Yeah, so I mean, I think uh, the reason that there have been so many comparisons to the Microsoft case with this case is just because this is the first monopoly case that the government has brought against a tech company since that case against Microsoft. And there's also, definitely like similarities in the legal theories that are being advanced, right? The issue in Microsoft case was that Microsoft was, pre-installing Internet Explorer on its computers, which made it hard for consumers to use other internet browsers if they wanted to, like Netscape. And that you can definitely see like the similarity with the government's argument that Google is using its power to make Google the default so that it's hard for users to use different browsers. Um, Google obviously doesn't see these cases, doesn't think these cases are the same, right? Like in their opening statement, they pointed out that it's a lot harder to, delete software and then re-download a new internet browser software in the 1990s than it is to switch your default engine. So that's one difference. And they also argue that, right, like people actually liked Netscape more than they liked Internet Explorer. So it was a company like forcing a worse product on consumers. And Google obviously thinks Google search is better than its competitors. So they're arguing that there's that difference too. But the Microsoft case, I mean, it's definitely a part of this trial, not only for those reasons, but also because, right, that Microsoft would probably benefit from a ruling against Google, since they're, even though Bing is much, much smaller than Google, that's at the moment Google's closest competitor in search. So there are a lot of parallels between this case and Microsoft, and it's definitely going to be part of the case as the trial unfolds.
So just what you said about people liking Google more and them having a better product just got me thinking about the innovation that we've seen in the last couple of months from Google, namely in AI and their Bard chatbot, and how they've kind of been playing catch up to Microsoft and OpenAI. Do you think that the discussion of AI and innovation in AI will be a significant part of this case? And then context to that, I read that when the Bell company was broken up into smaller Bell companies, the research lab that had come up with many different innovative new technologies had to shut down, because without the kind of conglomerate monopoly power, they had fewer profits and just couldn't sustain operating a speculative research lab. And some people have argued that the same could potentially happen with Google, that they are so innovative and on the kind of forefront of AI research, and then if they were broken up, then perhaps their ability to complete this research would be diminished. And that's not only that's kind of a national security issue at this point. So thoughts on how AI will play into this?
Yeah. I think, those are obviously like important questions. Yeah, again, I don't think I have like enough, knowledge to really speculate about it, but I think AI hasn't been a huge part of the case so far. Just, and part of that is because, right, we're, it's a trial, like it's about what's already happened. It's not, we can't, neither side can predict the future, although this case is definitely, both sides are trying to argue that like ruling for them is what's better for, future outcomes. But I think it will, I think it very well could be a part of Google's case, right? That, Google's size and scale is actually important to it being to creating such a great product. And that size, and so basically that its size and scale is actually pro-competitive. We haven't seen so much of that so far. The government has actually really been trying to push the argument that Google is, if Google is really the best, it's only the best because it has so much scale and data, not because it actually innovates. But both, Google can be great both because of its innovation and because of its scale. And so I think, we'll probably learn more about how much AI is going to feature in the trial once Google gets its chance to put on its defense, which won't happen for a few weeks. Right now, it's just the government's witnesses, and then Google just gets the chance to cross-examine. So I think at the moment it's still unclear how much that will be a part of the case. My name is Yosef Weitzman. I just graduated law school, but before my job as a lawyer starts, I'm actually taking a couple months to report on the antitrust monopoly case against Google, which is happening in Washington, D.C. And I'm writing for a Substack website called Bid Tech on Trial.
Thank you so much.